Good day, everyone. I'm Laura Williams, Managing Partner of Williams HR Law LLP, and I'm here to officially welcome you to the second installment of Williams HR Law's second Fall Hotspots webinar series. So glad you could find the time to tune in. Now, we conceptualized this webinar some years ago as something we believed would be valuable to business leaders, HR professionals, and anyone who has people management responsibilities. This series is intended to provide an update that focuses on the critical issues and developments in HR law that organizations routinely experience and which are becoming increasingly complex and costly in today's workplace environments. Today's webinar focus is on critical termination tactics. This topic made the fall series cut because employers are increasingly being scrutinized on how they conduct terminations of employment, and missteps, which are often unwittingly committed by employers, can be met with significant liability, cost, and impact to an organization's culture and reputation. So, guiding us through the key considerations related to terminations of employment will be Huynh and Faraz Kourangi, both experienced lawyers and workplace investigators of the firm. And the content that and Faraz will cover will include key considerations and best practices and strategies related to employment agreements and contractual terms. So, what terms and conditions are important. We're going to talk about restrictive covenants, which in today's climate are really important to consider whether or not you should have them in place. They're going to cover just cause and constructive dismissal, huge areas where if there are missteps, it can lead to significant costs and liability. And that includes a scope of increasing concern for employers, and that is how the termination is conducted, because you don't want to find yourself facing allegations that the manner of termination constituted bad faith conduct. So we're going to cover that. And then they're also going to discuss some post-employment considerations, and we'll wrap up with some key and critical considerations and takeaways for everyone that can, and we always ensure that they're practical and they're actionable. So with respect to your questions, which I'm sure you'll have some burning questions that relate to the content, please ensure that you populate them in the Q&A box. At the end of the content delivery, we'll have a live Q&A session when your burning questions will be answered. Now, just a caution there, the Q&A session won't be an opportunity for us to address specific legal issues that your organizations might be facing. A number of people try to slip in there. There kind of some free legal advice, but we are very cautious and guarded when it comes to that, because naturally, as lawyers, for us to provide you with specific guidance, we need to have more in-depth information. So our Q&A time is really for those general questions, and don't hold back, because naturally your questions may be questions in the mind of others. And we want to make sure that you get max value for your time spent with us today. So with that, I'm going to turn it over to Nii to kick us off. Over to you, Nii.
Thank you, Laura. Good afternoon, everyone. So the beginning of an employment relationship is a promising time to both employers and employees. At this time, many employers are typically focused on, securing their desired candidate, making sure that this employee is the right fit in terms of character and competence for their organization. And it's not always top of mind. It's not always top of mind for employers to really have important employment terms expressly written out so that both parties can know what to expect for the employee's tenure, but also for the eventual end of the relationship. And so in this section, I'm going to be talking about employment agreements and contractual terms, as Laura mentioned, but I'm going to be focusing on termination clauses mainly. Many employers know this is one of the most important employment terms, and termination clauses. The law on termination clauses has continued to shift year after year. We know that it can, be frustrating for employers to try and keep up, and then, they've put the time and money, and now they have to do a new update. But it's really important to, continue to keep these clauses or this clause updated along with several other considerations that I'll talk about. Because, in our practice, frequently we do assist clients with responding to wrongful dismissal claims, demands from dismissed employees. And when employers have an updated enforceable termination clause, which many of our clients do if they regularly update their employment agreements, we can take a strong stance. And often in these cases, employees will abandon their claims and they don't sue. That's going to be much more difficult to do if the termination clause is unenforceable and outdated. We've seen a lot of employers just feel that their hands are tied. They aren't letting go employees who just aren't right for the role or for other business reasons because they feel they can't afford to. And so I'm going to be discussing termination entitlements now and how enforceable termination clauses can reduce costs and help with that flexibility and that predictability that an enforceable termination clause can have on termination decisions. So let's talk about termination entitlements and considerations to help employers limit those termination entitlements of employees so they don't balloon. I'm just going to start off with some foundational context just to make sure that everybody's on the same page. For non-unionized employees, there's two sources of termination entitlements. First is statute. So in Ontario, that's the Employment Standards Act, or you'll hear me refer to the ESA. And that entitles employees to termination pay or pay in lieu of notice to a maximum of 8 weeks. And then some employees are going to be entitled to severance pay if the employer has at least a $2.5 million global payroll. And if that employee has worked for at least 5 years with that employer, they can receive severance pay to a maximum of 26 weeks. That might sound like a lot, but let's talk about the common law. So common law is the second source of termination entitlement, and that involves what judges interpret to be a reasonable notice period, looking at a particular employee's, certain factors. And those factors are typically the employee's age, their years of service, that's an important one, the nature of their position, compensation, the difficulty in finding comparable work in the market. And there can be other factors too. So when we're talking about common law and the maximum there, there's an unwritten cap of 24 months, but in extraordinary cases, it can be more. We've seen it, a case where it's been 30 months. And that's much more than what the maximum, statutory requirement provides. And so why does this matter? A poorly drafted or unenforceable termination clause or employment agreement will result in a non-unionized employee being entitled to those more significant common law entitlements. So it's really important to reduce your costs and to, again, provide you with that predictability at that time period to make sure that you have a properly drafted enforceable termination clause. Other considerations, we'll talk about jurisdictional considerations. We have some clients where they have employees all over different provinces. And it's important for those employers to understand that different provinces and territories will have their own laws that employers must comply with. And so it's very important to tailor their employment agreements with this in mind, and they shouldn't be using a blanket employment agreement that will apply in every location. For example, Ontario is the only province where employees are entitled to severance pay. In Nova Scotia, the Labor Standards Code provides that employees who have been there for at least 10 years, they can't be dismissed without cause. If you are going to dismiss an employee with that many years of service in Nova Scotia, you would need good reason or just cause. And so that's quite different from how it is in Ontario, for example. And then federally regulated employees are governed by the Canada Labor Code. And it also has its own set of rules. Previously, the maximum termination pay or pay in lieu of notice was 2 weeks. But starting in February of this year, it's looking more like what the ESA looks like. So now it's to a maximum of 8 weeks. and then as well as severance pay if applicable. But this is calculated differently than what it is under the ESA. So again, important to note. One last consideration is unionized versus non-unionized. So in unionized workplaces, common law doesn't exist. It's not available for the unionized employees. Their termination entitlements come from the collective agreement. And, more importantly, employers can't dismiss unionized employees unless they have just cause, unless that employee is in their probationary period. So when Laura was talking about important employment terms, probationary clauses, sometimes employers overlook this as an important clause, but it's actually quite important. In unionized settings, it's important to have that clause because that's the only way you'll be able to dismiss an employee without cause. And then even for non-unionized settings, it's important to have because it can protect employers from inducement claims. And inducement just means an employee is going to argue that, hey, employer, you've taken me from secure employment and, you've told me these false promises to get me to work with you when I could have been working at the secure job. If a court finds that an employee has been induced, they're going to, consider the employee's years of service with that previous employer in terms of, what they're owed with this current employer for their notice period. Let's move on to the enforceability of termination clauses. We've talked about the why. It's important that employers should ensure that their termination clauses are enforceable. But now let's talk about what makes an employment clause unenforceable. So typically that happens when the termination clause or some part of it violates statute. And it means that the employee now, is not provided with their statutory minimum entitlement. That's going to be the case whether the violation is an actual violation or a hypothetical one. So for example, if a termination clause doesn't clearly outline that benefits, must continue for the notice period, even if that particular employee doesn't receive benefits, that termination clause is going to be unenforceable and that employee is going to be entitled to common law reasonable notice. Again, it's a hypothetical violation in that case. Some employers think, well, maybe I could just throw in a savings clause or a severability clause in my termination clause. It's not perfectly drafted, but it'll be fine. That's unfortunately not going to save you. If your termination clause is unenforceable, a savings provision isn't going to save it and make it enforceable. A savings clause, for those of you who don't know, it just provides that the employee will receive at least their minimum entitlements in all circumstances. But again, if you're trying to, or not intending to, but you do contract out of those statutory minimum standards, that's not going to make your unenforceable termination clause enforceable. What a severability clause is it permits an illegal or offending part of a clause or agreement to be removed so that the remainder of the clause or agreement can remain valid. But again, this isn't going to save your termination clause also because courts have said termination clauses are too important for an employer not to properly draft. And that's because employees need to know what they're going to be entitled to at the end of the relationship, arguably, when they're going to be their most vulnerable. Along with ensuring that termination clauses are statutorily compliant, of course, that's important. Employers should make sure that they have properly drafted limiting language in their termination clauses if they want to limit the employee's termination entitlements. And while you can't contract out of statutory entitlements, you must explicitly contract out of common law reasonable notice to make sure that these entitlements are limited. Basically, employees should know that they're not going to receive more than what's expressly drafted in that termination clause. And then finally, the agreement requires consideration to be enforceable. This is, something that employers, we've seen, it's a commonly misunderstood concept. Most of you may know consideration, what that is. It can be anything of value that is given to the employee that's a benefit for signing the agreement that they're not already entitled to. So for new hires, That's going to be their job. You don't have to provide anything more than that. But when you're introducing an updated employment agreement to an employee that's existing in your organization, you have to provide fresh consideration. That can look like any amount. It doesn't have to be a big amount. We've seen $25 signing bonus, a gift card, an additional vacation day for that year that they sign. But it's important to get it right. The timing of consideration, we've seen, employers not always understand. It's important to provide the consideration only after the employee signs. If you do it before, that will render the employment agreement unenforceable. You don't want to be spending your time and money updating your employment agreements and then not be able to rely on them. So that's an important concept to get right. And then moving on to agreements and policies, it's important that, again, these are well drafted, regularly updated, and properly implemented. The reason being, courts are scrutinizing these important employment documents more and more to find ways to render termination clauses unenforceable or find that they're unenforceable. So I'll go through these cases quickly because I'm sure most of you have heard of them. But Waxdale, a few years ago, this impacted most termination clauses in Ontario, and they became unenforceable. The reason being is the court held that, all termination agreements are going to be read together. So even if you have a perfectly drafted without cause clause, that's enforceable. If your with cause clause violates statutory employment standards, the whole thing, is not going to be valid. In practice, what this was a lot of the clauses violated the willful misconduct standard under the ESA, which is a higher standard than the just cause clause. Essentially, there are going to be times where you have met just cause, but you haven't met this more stringent willful misconduct standard, and therefore the employee should be receiving their statutory minimums. Moving on to Henderson, we saw that courts will look outside of, past the termination clause to assess the enforceability of that clause. And so in Henderson, the termination clause itself, it was enforceable, but when the courts started looking elsewhere in the confidentiality clause and the conflict of interest clause, they found termination related language that violated the ESA. And the court held that, unenforceable termination language anywhere in the employment agreement is going to render your otherwise enforceable termination clause unenforceable. Given the way that the law is going and the trends are trending, it's going to be important that your policies are properly, worded as well. Many policies can include language that could impact the enforceability of termination clauses because they're statutorily non-compliant. For example, we've seen policies that use the American at-will language, where the employee isn't entitled to notice or pay in lieu of notice. We've seen language which state that if the policy is breached, then the employee isn't entitled to either notice or pay in lieu. Again, that would violate statute, and many employers could, face this risk without really knowing it. And so, that's a benefit of updating your policies. It's not just, for termination clause compliance, but again, a lot of new laws have come out this year. It's really important to update your policies, get your employees familiarized with your expectations and communicate the why. Just to make sure that people are buying into the policies. But again, important to also review for that termination compliance. I will touch upon Celestini very quickly. Basically, Celestini just is another reminder why employers should regularly update their agreements. If you've had an employee working for a long time and their role has shifted greatly, the court in Celestini found that because the, material terms, the role and the responsibilities were significantly changed, that actually eroded the agreement because it wasn't what they had intended to agree to at the beginning. They couldn't have thought that that was going to be the new responsibilities. And so, that actually entitled the employee to common law reasonable notice. It wasn't the same agreement. Now it's kind of a new role. So another important thing to consider, whether you need a new employment agreement when you have that many changes in an employee's role. Just moving on to the last one, the latest development, as many of you have known and have heard from us from our email blasts and our other webinars, Dufault was the last, major decision that rendered a lot of termination clauses invalid. Basically, the court found that, language where it says that employers can terminate in its sole discretion at any time, that's going to violate the ESA, where, there are certain times where employers are prohibited from terminating employees. For example, if they're trying to exercise their right and an employer reprises against them, that's not allowed, and you cannot dismiss at that time. So in this case, because the contract was for a fixed term, the employee was entitled to 101 weeks, which was the remainder of their contract. But just, a note, this legal principle applies in all cases, not just fixed term agreements. And then fixed term agreements, if anybody has spoken with me before, I'm not the biggest fan, and I will tell you why. You can use them, but you use them with extreme caution. What a fixed term agreement is, it's a contract with an explicit end date. And, most employers think, I just need this employee for a short period. I don't need them for more than a year. The thing that I would want to caution employers about using fixed term agreements is if you have an unenforceable termination clause in a fixed term agreement, like as we've seen with Dufault, the employee will be entitled to the remainder of the agreement, which can be years worth, even if they've only worked a few months, for example. So consult with an employment lawyer if you wish to use a fixed term agreement. There might be a more appropriate type of agreement you can use, but it's best to have that discussion. So I'm going to turn it over to Faraz now, who's going to be talking about restrictive covenants.
Thank you, Nee, and hi, everyone. Like Nee mentioned, I'm going to use this section to discuss restrictive covenants. So what are restrictive covenants? So as the name suggests, these are terms in an employment agreement that restrict what an employee can do during the term of the employment relationship and also for a certain period after the employment relationship. The three most common types of restrictive covenants include confidentiality clauses, non-solicitation clauses, and non-competition clauses. I'll discuss these in greater detail one by one, but for now, I wanted to quickly touch on why employers should care about restrictive covenants. So, employers invest a lot of time and energy developing their intellectual property, building client lists and so forth. Like they spend a lot of time on that, and of course have an interest in protecting their information and making sure their clients aren't being poached by departing employees. So, and these days, a lot of employees are being, they tend to be more entrepreneurial. Some employees might want to, leave their current place of employment and set up a competitive business. And in the process of doing so, they might steal confidential information. They might take client lists with them with the intention of contacting those clients and customers once they've left. So you need to be very mindful of that. Employees have new ways of doing these sorts of things now with the sort of widespread use of AI. So that's why it matters, and that's why it's important to get restrictive covenants in place, ideally at the outset of the employment relationship in an employment agreement. Now, that's not the only time you could get restrictive covenants in place. You could do it when, for example, you're asking an employee to sign an updated employment agreement when they're being promoted, for example, or, in negotiating with a departing employee, you could include restrictive covenants as a term of settlement. Lastly, before we get into the sort of specific restrictive covenants, I wanted to discuss the sort of competing interests at play. So like I mentioned, organizations, they invest significantly in their confidential information and in their customers and so forth. On the flip side, employees have a significant interest in securing alternative employment once they've left. Like they need to have an ability to, earn an income once they've left or if they've been dismissed. So these are the sort of competing interests that the courts take into consideration when considering whether or not to enforce a restrictive covenant. So now on the next slide, I'm going to discuss confidentiality clauses. So these are clauses that protect an employer's confidential information from unauthorized use or disclosure. It applies both during and after the employment relationship. And it's particularly important to have confidentiality clauses for sort of executive employees or any other employees who are going to have significant access to an employer's confidential information. So that would also include salespeople and people who work in IT and so forth. I mean, it's great to have confidentiality clauses for all employees. I should say that, but it's particularly important to focus on these for certain classes of employees. I also want to mention that, while it is great to have confidentiality clauses in a written employment agreement, and that's ideal, there are certain implied duties of confidentiality. I mean, these are implied into the employment relationship through the common law. So don't think that if you don't have confidentiality clauses in place, you don't have any recourse if an employee is stealing or misusing confidential information. But the advantage of having them in written agreements is that you could strengthen you could better protect your confidential information and sort of strengthen the employee's obligations in that respect. Moving on to non-solicitation clauses. So these clauses prevent employees from soliciting clients, customers, or employees of the business. They like confidentiality clauses. They apply both during and post-employment. You could set a certain period post-employment where these obligations are going to continue in effect. Typically, that's a matter of months to a number of years. And so for these clauses to be enforceable, they need to be reasonable in terms of their scope. So that's, what they prevent the employees from doing, and who they prevent the employees from soliciting. And they have to be reasonable in terms of duration. So that's the length of time that these obligations are going to be in effect. And they need to be reasonable in terms of geographic area. So for example, you could restrict employees from soliciting customers in Ontario, or you could prevent them from soliciting customers Canada-wide. So yeah, the courts consider the reasonableness of these clauses in terms of scope, duration, and geographic area to determine how reasonable of a restriction this is, and therefore how whether or not they're going to enforce it. Okay, moving on to non-competition clauses. These clauses restrict employees from working for a competitor once they've left your business. In Ontario, they've been banned recently, 2 years ago, by the Working for Workers Act. There are limited exceptions to this ban. So the exceptions are for C-suite executives, think CEOs, CFOs, and so forth. And then another exception is when a business is sold and the seller remains employed by the buyer. So a non-compete is permitted in that situation as well. Just like non-solicitation clauses, non-competition clauses have to be reasonable in terms of scope, duration, and geographic area. I will say, we often hear from clients, I want to be able to prevent this employee from joining any competitive business Canada-wide, even though the client only operates in Ontario and maybe one other province. You're better off narrowing the restrictions in place, because that's going to increase the likelihood that you could actually enforce those restrictions rather than having extremely sort of broad restrictions in place that completely prevent the employee from securing another role, because the court's likely not going to enforce a restriction like that. Okay. Now, with that said, I'm going to pass it back to Nee to take us through just cause and constructive dismissal.
Thanks, Faraz. So I spoke about the beginning of employment relationships. We're going to be talking about the end of employment relationships now. While we discussed dismissing employees without cause previously, there are going to be times when employment relationships don't really end in a manner that is desirable for either party, but it's going to be necessary sometimes. So in this section, as Faraz had mentioned, I'm going to be discussing just cause dismissals and constructive dismissals, starting with the just cause dismissals. So oftentimes employers are either too quick to find cause, or they feel that it's impossible and they think, I'm stuck with an employee that's not working out, but I can't let them go. It's important to note there are times that cause is met, and employers really just need to ensure that they're assessing the case properly before asserting cause. Just because we've seen in cases, getting it wrong can lead to extraordinary damages above and beyond those wrongful dismissal damages that the employee would also be entitled to. Even if the employer gets it right, they should still be prepared for the employee to push back. So what is just cause? Just cause occurs when the employee's conduct, something that they did, leads to a breakdown in the employment relationship, and that trust can't be repaired and the relationship cannot continue. It's a very high threshold to meet, as most of you know, because when you have just cause, you're disentitling the employee from all of their termination entitlements. With just cause, you either have it or you don't. There's no such thing as near cause. But in the first section, as I mentioned, the common law standard of just cause is different from the willful misconduct standard of Ontario. While some provinces do have that just cause standard, it's just important to note the different types of standards. You would have to look into the specific provincial employment agreement to know what standard you have to meet to make sure that, is this employee entitled to their statutory minimums, or can I, say that they're not entitled to anything? To support a just cause termination, progressive discipline is typically required. What does that mean? That means giving clear warnings to the employee about what they've done, so they're not surprised at the end and have a stack of warnings against them. Employees should be given the opportunity to improve, guidance and the time to do it. Misconduct should be addressed, once the employer learns of the issue. So it's going to be difficult if you learn about, Bob doing something and then coming to him 6 months after the fact and, telling him about this thing that you weren't happy with. Employees should also know the consequence of continuing to, continuing that particular misconduct or continuing that particular performance issue. And so we've helped a lot of employers with documenting progressive discipline, and documenting it's going to be important. The fact is going to be, unfortunately, sometimes employees, some of them are going to continue to engage in similar misconduct. And, often in these cases, it's great that the employer has that well-documented progressive discipline, because that can help support a for-cause dismissal if that's going to be appropriate for the case. So documentary evidence is key. There was a case called Cumberland and Maritime College and Forest Technology that came out last year. The court found that the employer did not meet the just cause standard because they didn't provide the employee clear warnings about his conduct. The employee had numerous inappropriate interactions with students and colleagues, and the employee was insubordinate. But again, the employer didn't, take these opportunities to raise the issue with the employee, give him a chance to improve, and just let him know what the consequence would be had he, were he to continue that misconduct. So the court actually acknowledged if these issues had been put to the employee's attention, it would have paved the way for a just cause dismissal. Unfortunately, that didn't happen. The just cause standard wasn't met, and so he should not have been deprived of his entitlements. Another thing to note is single incidents that are egregious enough can warrant a just cause dismissal as well. But with all just cause dismissals, there needs to be a contextual analysis about the facts and circumstances to, that will include the seriousness of the employee's conduct, but you also have to consider other things, what was the damage to the employer, look at the situation, the relationship between the employees and the employer, or if there are any other relationships to consider, any policies that you might have. The years of service can play a role in terms of context, the employee's disciplinary record, and the degree of trust that that particular position requires. So in Park and Costco Wholesale, also a case from last year, a 20-year service employee basically was not happy that somebody else got the position that he was vying for, and he deleted the website that he had built for the employer, not once but twice. The second time being after the employer had restored it. He deliberately misled the employer, saying, well, somebody hacked into my computer, I didn't do it. The evidence showed otherwise, and so the court found that these deliberate deletions and his dishonesty were major issues that actually met that higher standard of willful misconduct. And, the court also found the company had an internal policy regarding this, conduct that would lead to dismissal, including destroying property, which this was, deleting the websites was exactly that, and then insubordination. So just cause was held in this case, despite the employee's 20 years of service, and he had no prior, record. He had a clean record, but that was serious enough for the court to say that amounted to just cause. Workplace investigations can be key to discovering facts that can support a just cause dismissal. So just a word of caution, be careful. Employers must not assume the results of the investigation, should wait until they have all the facts, that the investigation has concluded, you've done your proper assessment of the evidence, findings are completed before even considering any corrective action, because again, you don't want to assume the results before the investigation has really completed. A proper investigation can make the world of difference. There have been times when we've, received demand letters after an employee was dismissed for cause because of, what they found in an investigation. We were able to push back on these demand letters, arguing there's, no case to what they're saying, because, these are all the steps that the employer did correctly, and these were the findings that came from that. What usually happens is the opposing counsel disappears, which is great for the employer. Employers should also keep in mind that the standard for these investigations is a balance of probabilities. So that's not the higher standard of beyond a reasonable doubt. It's really just, is it a slightly more, is it a hair more than 50%? If that's the case, you can come to findings. And then another thing to note, many employers these days are less inclined to outsource investigations, even though they don't have the capacity to do it internally. What they should be aware of is courts, more and more, they're significantly scrutinizing, investigations, how, if they were done properly, and then if they weren't, for example, if technical requirements are not met, such as assessing credibility and reliability, that can invalidate the findings and then take the legs right out of any corrective action decision. So organizations really need to ensure that they have the capacity and competence to take on investigations. And if they don't, consider outsourcing it. And then our firm will be hosting another complimentary webinar on November 21st about investigations. And, there will be more important insights about investigations then. So let's move quickly on to workplace policies. As I mentioned in the previous slide, progressive discipline is typically required when you want to support just cause. It's crucial to have well-drafted policies to really set out employer expectations about employee conduct and performance. If an employee has breached a very clear policy, discipline may be appropriate, but that discipline, again, should be grounded in policy. That includes the policy that the employer is intending to rely on, as well as its progressive discipline policy. Without policies, discipline is going to be hard to justify. So a real life example, AI policies are becoming more and more important as the use of AI is becoming increasingly frequent in the workplace and also in people's homes. AI policies can set expectations about the appropriate use of AI, to be able to rely on cases where the employer thinks they might need to discipline an employee. The employer should really outline, clearly what's acceptable and not acceptable use of AI. So if you don't want your employees using confidential information, when using AI programs, you need to make that clear. And then if they breach that policy, you can point to exactly what you're referring to and relying on. One last note about policies. Employers may think it's helpful to merely have policies in the first place, but if those policies are vague or inconsistently applied, that might actually be more harmful to your organization because that might breed feelings of unfairness in your employees if they're seeing Bob is being, again, I'm saying Bob, but Bob is being disciplined when Jane is not being disciplined for the same thing. So policies need to be clear, they need to be consistent, they need to be reasonable, and then any consequences need to be clearly outlined if the employee isn't following the policy. Policy, should also be, as I mentioned before, backed by a solid why. Otherwise, it's not going to be intuitive to your employees. Your employees aren't going to understand what expectations they need to follow, but also your managers, might not really understand when they're meant to implement something, and then they might implement the policy inconsistently. And again, that's not going to be helpful for the organization. Let's move on to constructive dismissal. What is constructive dismissal? That occurs when you haven't outright dismissed the employee, but they take it as they've been dismissed because they see the employer is no longer intends to be bound by the employment agreement, which can happen in two ways. First is, the employer might make a unilateral fundamental change to a material term. And then second, they might have created an intolerable workplace environment. And then the employee says, I've been pushed out of the workplace. So the first unilateral change to material terms, that can be changes to either monetary, like compensation benefits, or non-monetary items such as working location, working hours, working conditions. One important case from last year is FAM. In that case, the employee was laid off, the layoff was extended 3 times, and the employee brought a claim for constructive dismissal, essentially saying there was no term that allowed the employer the right to lay me off. And this is a unilateral fundamental change. The court agreed with the employee. Where an employment contract has no express term with respect to layoffs, that right isn't going to be readily implied. And a practice of, past practice of imposing layoffs, that's not going to establish that there is that implied right. Therefore, if you don't have a temporary layoff term in your employment agreement, and then if you impose the layoff, the court will see that as a unilateral change of a material term, and it's going to result in a constructive dismissal. Returning to work can be a unilateral change. It depends on, what depends on many factors. Employers have the general right to manage their affairs and the right to dictate the location of work, but it's got to be reasonable. What's reasonable will depend on what's discussed, what's promised, what's in the contemplation of the parties. If the contract promises remote or hybrid work arrangement, the employer is not going to be, able to unilaterally change that. If the contract is silent, but the employee has always worked remotely, that can, be a possible implied term. And then if the term has been unchanged for a lengthy period of time, that can also be, an implied term. Similarly, depending on the employment agreement of the employees, if the employer is relocating, this may lead to constructive dismissal claims, and we have helped our client prevent and mitigate these types of claims. The second is, way of constructive dismissal or way that an employee can claim constructive dismissal is an intolerable workplace environment. And this can happen in a series of acts, but it can also happen, it can happen in a series of acts where the employee says, I can't perform my duties anymore because of the intolerable workplace environment. That's going to be a high threshold for employees to meet. We've seen cases where employees aren't happy with the manager monitoring their work, but just because the employee doesn't like something doesn't mean that a reasonable person would find the workplace intolerable. Some things to note: employees might be noting their protest and teeing up to bring a constructive dismissal claim. There are telltale signs where an employee is very likely going to claim constructive dismissal after resigning. So if an employer is receiving these types of communications where they're protesting something, they're letting the employer know about an intolerable workplace environment, employers should seek legal advice. The reason being, let's talk about the consequences quickly. The employee may be entitled to extraordinary damages if they are found to be constructive dismissed. And again, that's above and beyond the wrongful dismissal damages. And lastly, constructive dismissal can have an impact on the employer's reputation. It can have an impact on employee morale. And so it's best for employers to stay proactive and then prevent these claims before they can happen. I'm going to pass it over to Faraz now, who will be discussing bad faith conduct.
Sorry for that. Thank you, Nee. Yes, so bad faith conduct refers to conduct on the part of an employer that is deceptive, dishonest, and so forth, like conduct that employers should not be engaging in, and that unfortunately they often do in dismissing an employee. And the issue with engaging in bad faith conduct is that it could, in addition to causing harm to the employee and resulting in a loss of their dignity and humiliating them and so forth, it could also create a real, liability for the business. Oftentimes in like a wrongful dismissal lawsuit, employers have to pay out sums that they didn't think they had bargained for. They're paying for reasonable notice of termination instead of the employee's minimum statutory entitlements. Well, when employers engage in bad faith conduct, they often have to pay out a lot more than just reasonable notice. In extreme cases, they could be liable to pay 250 grand for moral damages, 250 grand for punitive damages. I'm emphasizing that's in extreme cases. Typically, it's significantly less than that, but it's often way more than an employer would like to pay out. So on this next slide, I'm going to be discussing examples of bad faith conduct in the manner of dismissal. So one common example that we've been seeing is employers who fail to provide their employees with termination pay or their record of employment on time. So there are statutory deadlines to provide these amounts or to issue these documents. You also need to make sure that the amounts are accurate. The length of service noted in the record of employment is accurate. All those details should be double checked. Because courts have been reprimanding employers who fail to meet those obligations, because as you can imagine, when an employee loses their job, they're quite reliant on termination pay. They're relying on the employer to issue the record of employment on time so that they could apply for EI. So the courts have been seeing that sort of conduct as warranting additional damages. Another example of bad faith conduct is disguising the true reason for dismissal. Now, this doesn't mean you have to provide a reason for dismissal. If you're terminating an employee on a without cause basis, very often you won't want to provide a reason at all. But if you are going to provide a reason, you should be generally honest in that reason. You shouldn't say, we're terminating your employment for performance reasons, when in fact you don't have the funds to continue this employee's employment because the grants you were expecting didn't come in, just to give an example there. And Another example of bad faith conduct in the manner of dismissal is to conduct the dismissal or the termination meeting in a humiliating manner. So that would include, for example, having the termination meeting where others can see, in front of the employee's peers. It would include yelling at the employee during the termination meeting and so forth. So the trend that we've been seeing is that courts have sort of been lowering the bar in terms of the conduct on the part of an employer that's going to amount to bad faith. So like the first example I was giving, like not giving termination pay on time, these are sort of technical irregularities, and it happens all the time. But now courts are, employees counsel are leveraging those mistakes to to justify their requests for further damages, and courts have been quite amenable to those sorts of arguments. So key considerations to sort of reduce the risk of being reprimanded for bad faith. The first one is to establish a clear termination procedure. So it's a good idea to plan out in advance when you're going to provide termination pay, when you have to issue the record of employment, all those logistical things. It's good to sort of map out in advance and be consistent in how you're carrying out that procedure for each employee. Another key consideration is to take into account the timing and the reasons for the dismissal. As some of you may have heard us say, there is some additional risk when you're terminating an employee's employment just before the holidays. The reasoning being that the idea is that it's harder for them to find another job just like in the holiday season. So consider the timing. Also consider the timing with respect to, if the employee recently disclosed that they're about to undergo an operation, for example, or they recently disclosed that, raised a concern related to harassment or discrimination, etc. You're going to want to manage those, the perception that could be created if you're terminating an employee's employment around that time. Sometimes it makes sense to postpone determination until some time has passed or until the employee's concerns have been addressed. And we discussed, the importance of considering the reasons for dismissal. If it's on a without cause basis, usually you won't want to mention the reasons. And then another important consideration is to provide sufficient time for the employee to consider the termination package. We see all too often employers will provide, or they intend to provide employees with just a day or two to consider a termination package, just to put pressure on them to sign. Generally, we would advise against that. There are always exceptions, but generally you're going to want to make sure the employee has a week or so to consider and review a termination package. That is going to allow you to better defend against claims that they were under duress, or they didn't have sufficient time to obtain legal counsel before signing the release, and so forth. And then last key consideration I'm going to discuss has to do with documenting all communications and decisions relating to the dismissal. So even when you're going to dismiss an employee on a without cause basis, it's helpful to have some sort of written record as to the reasons for the dismissal. Some sort of written record of when the decision to dismiss the employee was made. These sorts of records can be important if an employee is saying, oh, well, they were dismissed because they requested accommodation, and they were dismissed because they raised concerns relating to harassment. Well, if you have a record that you could point to that's where this decision to terminate the employee's employment had nothing to do with them raising concerns or their accommodation request, and that decision was, it predated them raising concerns, you're going to be in a way better position to defend against those sorts of claims. So now on the next slide, I'm going to discuss bad faith post-employment. So, employers should pay attention not just to their conduct in the manner of dismissing an employee, like during the termination meeting and in the days surrounding the termination meeting. They should also pay attention to their conduct following, the end of the employment relationship, as that could also create exposure and, potential liability for moral damages. So the first one, which we touched on earlier, is it can be bad faith conduct to fail to fulfill your statutory and contractual obligations. So, for example, if under the employment agreement, you need to provide an employee with their commissions, and there's nothing limiting the employee's entitlement to commissions post-employment, like if you don't have the proper language in place in your incentive compensation plan, then and you have an obligation to provide those commissions, you must do so, and your failure to do so can result in additional damages. So that's that Klin decision noted there. Another example of bad faith conduct post-employment is to suddenly assert just cause for dismissal. So this is a situation where the employer dismisses the employee on a without cause basis, and then in the course of litigation, sort of flips the script and says, you know what, we have cause now, we've acquired cause to dismiss you, and you're therefore not entitled to any termination entitlements. So that was the case in the Griffin decision. Of course, both in the Klin and Griffin decision, the employers were required to pay moral damages over and above, damages for the reasonable notice period. So, these things really do happen. Another example is filing frivolous counterclaims. So sometimes employers, they'll want to sort of intimidate employees who are bringing lawsuits against them by filing counterclaims against the employee. Where those counterclaims are frivolous, where there's no merit to them whatsoever, and they're just intended to intimidate the employee, then that can result in additional damages being awarded against the employer. And then another example is causing unreasonable delays. And lastly, withholding evidence. So with that, I'm going to pass it back over to Nii to discuss post-employment considerations, beginning with the duty to mitigate. Sorry, thank you.
Thanks, Faraz. So after an employer has dismissed an employee, there are still further considerations to keep in mind to help employers, obtain more favorable settlements. As Faraz mentioned, I'm going to be discussing the employee's duty to mitigate and important considerations for employers. And then Faraz is going to finish off this section by discussing considerations for structuring termination packages where the employer is attempting to negotiate a settlement. So let's talk about mitigation. So oftentimes it's in the employer's best interest to help a dismissed employee secure comparable work, or in other words, to mitigate. Some employers might be thinking, now, why would I want to do that? Why would I want to help this employee find new work? Well, mitigation is an important employee obligation because it can offset the damages that the employer is liable to pay the employee in relation to their dismissal. This offset, however, only applies to the common law reasonable notice damages that exceed the statutory entitlements. Statutory entitlements the employee is entitled to no matter what. And then the offset doesn't apply to any income that the employee was already receiving, while they were employed with the employer, and would have continued to receive regardless of, their dismissal. So, for example, if the employee had an at-home side hustle, that wouldn't, offset the damages that the employer is liable to pay. So the duty to mitigate, as I mentioned, that's the duty, when an employee is dismissed, the courts don't really like it if an employee just sits on their hands, when they could be mitigating the damages by, searching and securing comparable employment. So if an employee successfully secures comparable employment, or if they make no effort to mitigate, their reasonable notice is typically reduced. What does comparable employment mean? So courts will look at factors, not just the nature, the type of work, and not just compensation and benefits, but geographical location. So if you're helping the employee look for work, but you're providing them with job postings for a job, in Manitoba, that's not going to be as helpful unless they work remotely, but otherwise not as helpful. We've seen cases where employees have applied for jobs that are well beyond what their experience would suggest that they're able to do, and they wouldn't be interviewed, and they wouldn't be offered a job because, again, it's very different from what they've normally done. Courts will say that's not comparable. And then courts will also look at the employee's personal life situation. Maybe they need, a lot of accommodation for a certain reason. And then the court will also look at whether the employer has made efforts to assist the employee with their job search. So one thing to note is that courts in the past few years have been very lenient when it comes to employee mitigation. So even if the employee is only, potentially only looked for 2 or 3 jobs in the month, there have been cases where the court has says, that still counts as reasonable mitigation. It depends on the facts, but courts are looking for ways to be more lenient with employees. Also, the onus is on the employer to show that the employee failed to mitigate. So that, again, becoming more and more difficult for the employer to show. The employer has to show that the employee failed to make reasonable efforts to find comparable work, and that the employee likely, could have secured that comparable work had those reasonable efforts been made. Still, we have helped employers, with respect to helping the employee to mitigate. And so one thing employers can do is they can begin collecting evidence of that dismissed employee's efforts to mitigate their losses, even before litigation, and then also help provide the employee with job postings, whether that's links or screenshots to job postings, referrals, reference letters can be very helpful. They can even help arrange interviews with industry affiliates. And so we've seen employers do that. There was a case, Gannon in Kinsdale. That employee was dismissed after 22 years of service because of business closure. The employer actually, took a lot of steps to help assist the employee with mitigation. They recommended the employee to the industry contracts. They arranged an interview for her. The employee actually received a new job offer, but rejected it. She claimed that the position wasn't comparable. The court disagreed. The court actually found that the position was comparable with respect to her position, her pay, her benefits. And because the employer had documented their efforts to help her and had evidence that, she did have a job offer but declined, the court found that the employee was not entitled to her reasonable notice damages, which would have been a lot. Again, she was a 22-year service employee. One thing to note is, sometimes I speak with employers and some of them aren't comfortable with connecting that particular employee to other organizations in the industry, given the employee's misconduct or performance. Valid considerations. But, there are other ways that an employer can still assist an employee in finding available jobs. And I had mentioned, again, just sending the job postings and so on. So I'm going to turn it over to Faraz to discuss structuring a termination package and settlement.
Thank you, Neve. So now that, we're in this process where you've dismissed the employee and they've retained a lawyer and we're negotiating back and forth the settlement package, the severance package, couple important things to keep in mind. So generally, you'll structure a termination package as either a lump sum or a salary continuance. It could also be both in certain instances where you're providing a lump sum but maintaining their salary for a certain period as well. Generally, the lump sum option is going to be a slightly reduced amount versus the salary continuance option. And that's because with the salary continuance option, it's typically coupled with a clawback provision. So that's the term in the settlement document that says if the employee manages to secure another role during the notice period, then a certain portion of the funds that remain to be paid will be clawed back, so it won't be paid out, and the employee will end up with a sort of less, smaller amount at the end of the day. With the lump sum option, we don't typically include these clawback provisions, so the lump sum has to be a smaller amount. So, in structuring termination packages, it's important to consider, what's important for both sides. So for the employer, you need to consider whether or not you can pay out a large lump sum all at once and sort of the impact that's going to have on the finances of your business, or whether, you would prefer to maintain the employee's salary for a certain period of time. Or you might prefer to avoid the sort of administrative burden that the salary continuance creates. So keep those things in mind. From the employee's perspective, more often than not, employees tend to prefer the lump sum option. And that's just because there's not going to be a clawback if they get another job. So, they get this large lump sum and it's still open for them to secure another role. So they're getting sort of double pay for a certain period of time. But very often employees will prefer the salary continuance option. We typically see that where the employees are on the older side, or they have no intention of finding another job anytime soon. So they would rather take the salary continuance option, for an extended period of time. Employees often also opt for a salary continuance where they have health issues requiring them to be off from work for a period of time. So keep those things in mind. Another important thing to keep in mind is sort of what benefits are important to the employee. Some employees, health benefits are extremely important to them. They might be having some certain health issues, or they may need the benefits for their families, so they'll prioritize. They might be willing to take a discount on the lump sum for a lengthier benefits continuation period. So it would, it's in your interest to sort of understand what the employee wants and what they value, because that could allow you to get a better deal when negotiating these severance packages. Then other things to keep in mind. So settlement funds can be allocated in different ways. The most sort of conventional allocation is just straight employment income. So you're saying we're offering you this certain amount. It's equivalent to 10 months of pay, to give you an example. But another possible way of characterizing the funds is as general damages. So we discussed bad faith earlier, moral damages, punitive damages. So, amounts that are paid to an employee to compensate them for the employer's bad faith or for the employer's egregious conduct. These amounts are typically, they're described as general damages. They're tax-free. So employee doesn't pay tax on these amounts. And so it's important to consider if that is applicable in the situation. If the employee has raised these kinds of allegations, like they've been harassed, they've been discriminated against, that opens up the door to potentially characterize some of the funds as general damages. So the employee is not paying tax on that amount. And as a result of that benefit to the employee, employers are usually able to sort of reduce the amount they're paying to the employee. So it can be part of a sort of a win-win settlement. And another sort of thing to keep in mind, another possibility in structuring termination packages is to contribute a portion of the settlement funds directly to the employee's RRSP. And so the tax in that case is going to be deferred until the employee withdraws the funds from their RRSP. So that's a benefit to the employee that doesn't cost the employer anything additional. It's a way of incentivizing the employee to accept an amount they otherwise might not accept. And then lastly is legal fees. So when you allocate a portion of settlement funds as legal fees, that portion is tax deductible to the employee. So there's an additional tax advantage there to the employee that doesn't cost the employer anything more. It's another tool we can use to save save money for organizations, and it really creates a win-win situation. Okay, and with that, going to move on to key takeaways. Beginning with myself. So I'm going to recap some of the things we discussed with respect to employment agreements and restrictive covenants on this next slide. So if you haven't updated your employment agreements and policies this year, it's important to do so to remain legally compliant. Nhi was taking us earlier in this presentation. She was taking us through certain recent legal developments, in particular the Dufault decision. So if you haven't had your policies and agreements updated this year, we encourage you to do so to make sure that you're able to rely on your termination clauses. Next, sort of take a look at the restrictive covenants in your employment agreements to ensure that they're reasonable in scope, duration, and geographic area. If you don't have restrictive covenants in place already and would like to have those, sort of identify, your business and your sort of the assets you want to protect, identify which areas that you have customers, and sort of determine what is the least restrictive, terms that we could put in place that still sufficiently protect your interests. Keep in mind, as I mentioned earlier, non-competition clauses are generally unenforceable rather, with the exception of C-suite executives and in the context of a sale of a business. And also another key takeaway is that while it's best to agree to restrictive covenants at the outset of an employment relationship, they can also be included during the employment relationship or at the end of the employment relationship in negotiating a termination package. Okay, and then Nhi is going to take us through the next set of takeaways.
So in terms of just cause, constructive dismissal, takeaways and workplace policy takeaways, it's important to assess whether the high threshold of just cause or willful misconduct have been met. It can be very costly if you get this wrong. Obviously, don't want to, tell employers to freeze and not be able to do anything, but you have to take the time to make the proper assessment. Otherwise, again, extraordinary damages can result on top of the wrongful dismissal damages. When we're talking about constructive dismissal, if you know, for example, you're going to be changing a fundamental employment term, such as you're going to relocate your organization, have a plan in place. Definitely consult with a lawyer, because there are steps that you can take to mitigate constructive dismissal claims and then, any damages arising from such claims. One important takeaway with respect to investigations: consider whether your organization has the capacity and competence to carry out an investigation. And if you think of as an investigation will take you this long, and those who have done investigations will know, it will really take you this long, because I don't think my camera captures this. It will really take you much longer than you anticipate, because there could be more allegations and more witnesses that you have to interview. So, consider whether you have that capacity. A flawed investigation can affect whether, again, you have support for your just cause or support for your discipline. And then a flawed investigation can also attract punitive damages, aggravated damages. So you want to make sure that you get it right. And then, lastly, what we're talking about, implement well-drafted policies, make sure that you're clearly setting out expectations so that all levels of employees understand, what's expected of them, how the policy will be implemented. And then, having these policies in place will help to support any disciplinary decisions that you need to make. And then I'm going to turn it to Faraz to take us through to the last takeaways.
Thanks, Nee. So last set of takeaways relates to bad faith again, very important sort of concept to keep in mind. What I suggest that you do is to establish a clear termination procedure, including a termination checklist and script. It's helpful to plan out in advance what you're going to say. If you have that written script that you've prepared in advance, if an employee later says that you said something during the termination meeting that you didn't actually say, you can point to that script that you had prepared. And then the value of the checklist, again, is to make sure you're not missing deadlines and that you're being accurate in sort of the amounts you're reporting and then the sort of the length of service and so forth. So a lot goes on when you're dismissing an employee. The termination letter has to go out, you got to have the meeting, you got to issue this and that payment and, records of employment, all of those things. If you just map out in advance, it'll be, you'll find that helpful. Another takeaway is to maintain professionalism in the manner of dismissal. So both in the sort of the period leading up to the dismissal and also during the actual termination meeting. And then, in your interactions with the employee or the employee's counsel following termination of employment, always maintain professionalism and make sure you're fulfilling your statutory and contractual obligations. Another key takeaway is to document all communications with employees, as well as internal communications relating to the decision to terminate an employee's employment. Again, it's helpful to rely on those sorts of communications in the events of litigation. Then lastly, key takeaway is to avoid unnecessary litigation tactics or delays. An example that I provided earlier being to file frivolous lawsuits against the employee, sort of to intimidate them. So with that, going to turn it back over to Laura, I believe, and we're going to begin the Q&A session soon.
Well, thank you, Faraz and Nee. That was an excellent run through of critical termination concepts, tactics, tips, strategies, and just some really good actionable takeaways that I hope everybody that has joined us will note. One thing before we get to the Q&A, and thank you to those of you that put your burning questions in the Q&A box, we're going to turn to them now. But before we do, I just want to give you a quick reminder to join yours truly, Alexandra Pressey and Ingrid Rabeau of the firm, where we're going to deal with another really critical and an emerging area of risk and liability that employers can face as it relates to conducting investigations. There's been a lot of developments in this area where investigations are being tire kicked, challenged, pressure tested with the intention to invalidate the investigation process and undermine the findings upon which decisions that employers make that essentially invalidate the decisions. Because if you have decisions that are relying on investigation findings and you can find flaws in that process, then the decisions are going to not be enforceable. And again, it can create major issues, costs and liabilities for employers. So we're going to level up your understanding of the developments in that regard, and that's on November 21st, 2024, of course. So please feel free to join us for that webinar, which will be the final in our fall series. With that, let's turn to the Q&A segment so we can address the questions that have arisen from our content today. So I'm going to ask you, Faraz and Nee, to return. And let's dive right in and see if we can get through all of the questions that have been asked. So, Nia, I'm going to start with you. First question is, does it make sense to also have a clause outside of the probation period clause to cover inducement?
Thanks, Laura. So I know that the typical lawyer answer is it depends, but I'm actually going to go against that and say absolutely, it's a good idea. We actually have inducement clauses in our employment agreements that we draft. That says the employee acknowledges that they haven't been induced, but a probationary clause also does to support that the employee hasn't been induced, is to signify that there wasn't a promise from the employer that this employee is going to have secure employment. They need to be monitored for their suitability just like every other employee, and that's why I was talking about probationary periods being clauses rather being helpful, but the inducement clause is also a great thing to include in the employment agreement.
Thanks for that, Nee. Faraz, for you, regarding fixed term agreements, what do you suggest when we need to backfill for someone going on a 12+ month maternity leave? We wouldn't need a permanent employee, only someone to backfill during the leave. What say you in response to that question?
So in those situations, fixed term agreements can actually be, suitable to enter into with the employee. I know we generally do not recommend fixed term agreements when the intention is to have an employee fixed term employment agreements can be suitable. I will say it's good to build in some flexibility within the employment agreement to be able to adjust the term of the agreement, because sometimes when someone is on a mat leave, they might come earlier, they might come later than you would expect. So you should keep in mind, have that flexibility to be able to request this replacement employee to stay on longer or to leave a bit earlier. You should also set the expectation with this replacement employee that they're being brought on a temporary basis. They're being asked to fill in for a mat leave, so that there aren't any surprises there. Also keep in mind, you could potentially be liable to provide notice of termination depending on the length of the agreement that you're entering into with this replacement employee. Keep that in mind, and also keep in mind that one option might be to provide working notice of termination. So I'm rambling a little bit. Just in short, the answer is yes, you can use a fixed term employment agreement in those situations.
Well, I'll say this, I didn't take you at rambling in terms of hearing you, because I know, and we should always impress upon those listening, that it's usually not just a silver bullet answer. There are some kind of related considerations that you always need to make when you're implementing any employment agreement terms with employees. So, Nee, this harkens back to, again, where you kicked us off when we were talking about employment agreements and confidentiality terms. You mentioned that in Nova Scotia, employers cannot terminate without cause after 10 years of employment. In Ontario, can a government organization terminate a long service, 10+ years, employee without cause, without providing a reason, considering there were no performance or attendance issues?
So if it's a without cause dismissal and the employee isn't unionized, whether they're federally regulated or provincially regulated, you can dismiss without cause. You don't need a reason when you're dismissing without cause. More to speak on that in a little bit, but you just need to make sure that you're paying the employee their proper entitlements, and at the very least, their statutory entitlements. With respect to reasons, so without cause, it doesn't necessarily mean, it could be your restructuring. It could be any reason that is completely unrelated to the employee and their conduct and their performance. Sometimes if you do add a reason, this can kind of backfire because the employee, will think, well, this is unfair. I wasn't really provided with an opportunity to respond to this misconduct allegation or performance issue allegation. Why are you telling me I'm being dismissed for this when it was never brought to my attention? Sometimes strategically, it is better to provide a reason, because otherwise due to timing and optics, the employee might think it's something else that is really completely unrelated. They might think it's discriminatory or something else, that it really does make sense to provide a reason. So these are things to consider, but without cause terminations, you don't need a reason.
All right. Thanks for that, Nee. Faraz, this one's coming your way. Our employment letters have a 6-month probationary period, and many managers believe employees can be terminated without performance management documentation during this period, as the employees are on probation. Can you comment on this common belief?
So when you're terminating an employee on a without cause basis, you don't necessarily have to have performance management documentation. That said, I think we almost always recommend managers to keep that documentation, keep records of the performance management. Even though you're terminating the employee during the probationary period and on a without cause basis, if the employee is, calling into question the true reasons for their dismissal, if they're claiming, for example, that they're being discriminated against, or they're being retaliated, this is in retaliation for them raising a complaint, that sort of documentation can be very useful to sort of counter those sorts of allegations. Yeah, and then other than that, just keep in mind, because a lot of common misunderstanding, misperception is that if you have a 6-month-long probationary period, you can dismiss an employee and not pay them any termination entitlements. That's not necessarily the case. If the employee's employment, exceeds 3 months in Ontario, then you still have to provide them with their minimum statutory entitlements, regardless of whether they have a 6-month-long probationary period.
Excellent. Thanks, Faraz. Okay, 2 minutes to go, 3 questions left. Let's see if we can get through them. So, Nee, could a seasonal layoff policy benefit the company when there is a history of them, but not all employees have employment contracts, and introducing them is not really an option?
I would say this can be risky. There's no case law that I'm aware of having a layoff policy without the employment agreement is going to, be sufficient, but it can be risky given the general principles out there. A term like that is best crystallized in an employment agreement, where a court is much more likely to enforce the term. But it can also depend on how the policy was implemented. Was there consideration? Was there a signature? Like how it was familiarized to the employee and brought to their attention. Practically, a policy can set that expectation, such that the practice is normalized for the employee. They're not going to take issue with it, and that can be beneficial for the employer. But legally, it really is important to have specific terms that you want to bind a particular individual employee. That should be in an employment agreement. You had mentioned that that's potentially not possible, but speak to an employment lawyer and see whether that might be possible, because there are
advice on this one is a good way forward for sure, because it is tricky. In the last moments left, Faraz, is there a case supporting frivolous counterclaims resulting in punitive damages? I can't speak.
Yeah, it definitely is. That's the Griffin Integrated Securities Technologies and Valley Associates Inc. decision. So we've linked the Griffin decision on one of the slides. I could also copy and paste the link from our blog. That'll take you there, and it'll give you a better sense.
Yeah, and also too, there was a question about going back to the takeaway slide. Just note that attendees, you're going to get a copy of the deck, and there are hyperlinks to the cases and blogs, so you will be able to follow up. And then just finally, Nee, with the last moments left, with remote work Can an employee just move to a different province without notifying you? If they do, does their contract become non-enforceable?
Oof, well, I can say very clearly it can certainly cause a lot of problems. I mean, it will depend on factors. How long was the employee, in that different province for? But it can cause different issues because, the health and safety legislation that can apply might be different. The workplace compensation, where the jurisdiction, of the contract should be, the venue should be. And the longer the employee stays in this different province, the more problematic it can be with respect to different areas. So what you want to do is make sure you have a policy in place or employment terms in place, that require the employee to notify you if they're, going to be going to a different province, and maybe, how long they can stay in a different place. Being proactive and getting ahead of it will help you prevent some of the issues that would come with that.
And having solid policies on your working arrangements and expectations and making sure those things are tight, because there can be implications and you don't want to be caught by that sleeper issue for sure. So with that, I thank everyone. Well, first of all, thank you, me and Faraz. You did an outstanding job walking us through critical termination tactics, and everyone that took the time out of, we know all our schedules are booked and busy, to join us today. We thank you so much. Hope you got some value, and that some of the takeaways and items that we've shared with you and insights, that you'll be able to action them within your workplace to reduce any exposure to liability as it relates to terminations of employment. Until next time, be well.